Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if an employee refused to work due to religious belief? How far must an employer accommodate? Now, in recent years, the issue of discrimination in the workplace has garnered significant attention, particularly regarding how employers accommodate employees' religious beliefs while fulfilling the inherent requirements of their role. The case of Sun International Management Limited versus Sahiti serves as a pivotal reference point in examining this balance. This case, which was adjudicated by the Labour Appeal Court, highlights the complexities that arise when an employee's religious practices conflict with job expectations. Let's unpack the facts, the court's decisions, and what it means for employers moving forward. In terms of the facts, Mr. Sahiti, a Seventh-day Adventist, was appointed as the group manager of sales at Sun International. His employment contract stipulated standard working hours from 8:30 to 5 o'clock, Monday to Friday, with the expectation of working longer hours as needed. Importantly, colleagues, the contract did not explicitly require weekend work, which became a significant point of contention. 2 months into his employment, Mr. Sahiti disclosed his religious observation that prevented him from working from sunset on Friday to sunset on Saturday, the Sabbath. Initially, Sun International sought to accommodate Mr. Sahiti by allowing him to refrain from working during this period and relying on his manager to assume his responsibilities during the Sabbath. However, after 16 months, the situation became untenable, leading to an incapacity inquiry. Sun International argued that weekend work was an inherent requirement of the job, ultimately terminating Mr. Sahiti's employment for incapacity after he declined an alternative position that involved a substantial salary reduction. Upon referral to the Labour Court, Mr. Sahiti claimed that his dismissal was automatically unfair due to the discrimination based on his religion as outlined in Section 187 of the Labour Relations Act. The Labour Court ruled in his favour, determining that Sun International had failed to prove that weekend work was an inherent job requirement and that it had not adequately accommodated Mr. Sahiti's religious practices. Sun International appealed the decision to the Labour Appeal Court, which delivered a nuanced judgment featuring both majority and minority opinions. The Labour Appeal Court agreed that while working weekends was an inherent requirement of Mr. Sahiti's position, the key question was whether the employer had fulfilled its duty to reasonably accommodate his religious beliefs. The majority judgment ultimately found that Sun International had made reasonable attempts to accommodate Mr. Sahiti's needs, but the continued accommodation had become unsustainable. Therefore, the Labour Appeal Court overturned the Labour Court's decision, ruling that Mr. Sahiti's dismissal was not automatically unfair. Now, colleagues, what are the key takeaways for employers? Firstly, in terms of establishing inherent job requirements, employers must clearly identify and justify the inherent requirements of a job. This includes demonstrating that any such requirement is rationally connected to the position and necessary for fulfilling the legitimate work purposes. In terms of the duty to accommodate, while employers are required to make reasonable accommodations for employees' religious beliefs, they are not obligated to endure undue hardship or create new roles solely to accommodate these beliefs. The balance between operational needs and employee rights must be carefully navigated. Colleagues, it's essential for employers to document their efforts to accommodate employees and to communicate clearly regarding job expectations during the hiring process. This can help prevent misunderstandings and potential disputes regarding job requirements. Employers should remain informed about the legal provisions surrounding discrimination and accommodation as outlined in the Labour Relations Act as well as in the Employment Equity Act, and understanding the distinction between these laws is crucial for effective compliance and risk management. As the landscape of workplace discrimination continues to evolve, this case underscores the importance of proactive engagement and careful consideration of both employees' rights and operational requirements. Colleagues, that brings us to the end of this week's episode. Thank you for joining us, and we hope you found our discussion informative. If you have any questions or comments, we would love to hear from you. You can find us on social media or email me at wp@massconsulting.co.za. Till next time, bye-bye.